Hi there. Today I want to talk to you about the Rouleau report about the federal government's use of the Emergencies Act, and I'm going to tell you what I think this report got wrong a lot, and why this isn't the end for the Trudeau government. I can't wait to tell you all about it. If you're new here, welcome. My name is Christine, and I'm the litigation director for the Canadian Constitution Foundation, which is a legal charity that fights for fundamental freedoms in Canada. We were also a party to the Emergencies Act inquiry. I upload regular videos about our ongoing cases and about other interesting developments in constitutional law in Canada. So if that sounds like something you'd be interested in, please hit like and subscribe below. It really helps my videos out a lot. Also, please remember that nothing in my videos is legal advice. If you have your own legal question or problem, please consult your own lawyer. So on February 17th, Commissioner Rouleau released the final report of the Public Order Emergency Commission. This was the public inquiry into the Trudeau government's decision to invoke the Emergencies Act in response to the 2022 Freedom Convoy. We immediately reviewed the report and responded with a statement. The report was very disappointing. I know Commissioner Rouleau had a really hard job. The report was produced on an exceptionally tight timeline following 6 weeks of sitting through hearings, and the report is over 2,000 pages when you include the exhibits. But frankly, the report is exceptionally and overly deferential to the government. The real nub of the report sees Rouleau concluding the cabinet was justified in invoking the Emergencies Act on February 14th, 2022. The commissioner found there was credible and compelling evidence supporting both a subjective and objective reasonable belief in the existence of a public order emergency. The decision to invoke the act was appropriate, according to Commissioner Rouleau. This tone is cautious and measured, and it's an exercise, I think, in pointed diplomacy and balancing, but really wanting in clarity. First, for Rouleau to arrive at this conclusion, given the posture of federal cabinet witnesses at the hearings, it implies an extraordinary amount of deference to a carefully shielded government decision-making process. The entire basis of cabinet's concern that the protests had evolved into an unmanageable situation remained completely opaque to the commission. Remember, there was this exchange where Attorney General Lametti claimed that cabinet, in invoking the act, was acting on the basis of a legal opinion that he said held that threats to the security of Canada were met within the meaning of the act. And it was necessary to refer to this legal opinion because the overwhelming evidence from actors and decision makers who were receiving on the ground intelligence from Ottawa was completely to the contrary. For example, during the hearings, we heard from the director of CSIS, who had concluded that the Act's thresholds to threats to the security of Canada were not met. We also heard leadership from the Ottawa Police Services, the OPP, and the RCMP state that existing criminal law tools were sufficient. No other threat or assessment of the inadequacy of existing legal authorities was performed independently of the country's law enforcement. There was virtually no substantive basis upon which cabinet could have concluded that the circumstances in Ottawa met the threshold for invoking the act. This whole opaqueness led to one of the more memorable exchanges in the commission when one of the lawyers for the commission, his name is Gordon Cameron, sort of resisted the conclusion of Attorney General Lametti's evidence. He said, "Commissioner Rouleau, we are in a conundrum. We have attempted to find a way to lift the veil that has created a black box around what has turned out to be a central issue in the hearing. Keep in mind that assessing the reasonableness of cabinet's decision was the whole crux of the inquiry." Rouleau then addressed the Attorney General directly, and he said, Lametti, I'm having a little trouble. How do we assess reasonableness when we don't know what cabinet decision makers were acting on? Do we just presume good faith? And Lametti, of course, was happy to affirm this. And then judging by Rouleau's conclusion in this final report, it looks like presuming good faith indeed turned out to be sufficient for him. Remember, a requirement of invoking the Emergencies Act is that it is a measure of last resort. Specifically, the Act says the emergency cannot be effectively dealt with under any other federal law. The report emphasizes the word effectively, calling it an important modifier. And this seems to confuse this requirement that all other avenues of action be exhausted with a sort of argument of convenience. The report says there may be situations where other federal laws could technically apply to a situation but still fall short. Practical considerations must be taken into account, such as whether the resources exist to enforce existing authorities, whether they would be effective in resolving the situation in a timely way, and whether they would address the situation safely. Essentially, incompetence may be what the new threshold is, according to this report. Evidence from law enforcement was that at best, the boost provided by the Emergencies Act was helpful in resolving the protests, but it did not actually substantially alter the plan to clear the protests that had already been put into place by February 13th, before the Emergencies Act was invoked. Laws that already existed in the criminal code gave law enforcement the tools it needed and that they ultimately used to clear the disruptive protests, to compel tow truck operators to remove illegally parked trucks, and to call in reinforcement police from across the country. The report both acknowledges and dismisses this, saying, although there continued to be laws such as the criminal code that, if effectively used, could bring the protest under control, it was apparent that law enforcement had serious reservations. This is bizarre because not a single law enforcement witness testified that they requested the invocation of the act, nor that they needed more tools than already existed at their disposal. Now, Rouleau in his report is also harshly critical of the Ottawa Police Services in general and a former chief Slowly in particular. He cites a breakdown in communication, in incident command, and a breakdown even in the system that the police had to ensure that their own intelligence reports were disseminated. All of this, I think, is probably justified criticism. But for Rouleau to use these findings about the chaos among law enforcement and the finding about insufficiency in state capacity to respond to a crisis is really just a way of bootstrapping the invocation of emergency powers, and it is a lamentable and even dangerous precedent. Incompetence and chaos is not the legal threshold. Finally, the report seems to accept the federal government's novel and even Hail Mary type of legal argument that the definition of threat to the security of Canada in the Emergencies Act is different from the definition in the CSIS Act, even though that definition is incorporated by reference into the Emergencies Act. The report finds that the two decision makers, each interpreting the same words in the context of different statutes, can reasonably come to different conclusions as to whether the threshold is met. We disagree. And in fact, I think that this argument is dangerously misguided. It clearly strains the well-documented intention of Minister Perrin Beatty and the drafters of the Emergencies Act, who were very careful in intentionally incorporating the CSIS definition into the Emergencies Act. They specified that the definition, threats to the security of Canada, is the same as that in the CSIS Act, right in the text of the statute. And that standard was intentionally meant to be, to use Beatty's words, very stringent indeed. But the argument goes from, I think, misguided to entirely untenable when you consider what we heard from evidence from each of the relevant inputs about who would have been aware of on-the-ground situations. And not a single one of these on-the-ground policing or intelligence officers testified that a threat to national security was met. The report gives Cabinet this huge, wide spectrum of reasonableness in invoking the Act that is completely unsupported by the statute's strict definition. Commissioner Rouleau doesn't quite find that an actual situation presenting threats to the national security of Canada has crystallized. In his conclusion, he writes that the situation Cabinet was facing was worsening and at risk of becoming dangerous and unmanageable. In other words, there was kind of this, whiff of danger in the air. And Rouleau makes a great deal out of the diagonal paraphernalia recovered in Coutts, Alberta, inferring that it might suggest similar ideologically motivated extremist factors might materialize in Ottawa, even though no policing witnesses testified that there was any evidence of such a presence. And Rouleau acknowledges that no links like that were found. So, fearful of this whiff of danger, Rouleau found that cabinet was reasonable in invoking these emergency powers. Now, this scope of latitude and deference is appropriate for assessing, on the ground contingent actions of police who indeed we properly give wide operating bandwidth to. But the same standard is completely inappropriate for sitting properly briefed cabinets' sober deliberations in the face of well-established and a rightfully high legal threshold for invoking the extraordinary powers to detain peaceful protesters and freeze bank accounts without due process, and to suspend insurance throughout all of Canada. But this report, as I have said, is not the last word on whether the Trudeau government's use of the Emergencies Act was legal. We have brought a federal court judicial review of the use of the Emergencies Act, and there has been a hearing scheduled for April. Now, this judicial review has been brought independently, unlike the commission, which was convened and appointed by the government. And that decision will carry the binding force of law, unlike the commission report. Now, depending on the outcome of that judicial review, there may yet, and we hope there will be, consequences for what we think is the government's illegal use of the Emergencies Act and the unconstitutional regulations created under the Emergencies Act. If you want to find out more about that judicial review as it progresses, I'm going to have updates. I'm planning on actually live streaming from Ottawa each day after the hearings, just as I did when I was in Ottawa for the Public Order Emergency Commission. So be sure to subscribe to the channel, and you should see a little bell icon below if you look underneath under this video. And if you click on that bell icon, you will get a notification when I'm about to go live. So you can watch all of those videos live as they happen in April. You can also sign up for our email Freedom Updates so you receive information about this case and everything else that we are working on if you visit the ccf.ca/freedom updates. And I will also post a link below in the description to the entire Rouleau report. As I said, it's over 2,000 pages when you include the exhibits. So I would love if you can go through it as well, and if you want to point me to anything that you found particularly interesting. And of course, if you want to support our fight against the federal government's illegal and unconstitutional use of the Emergencies Act, you can donate to our legal fees, which are quite high, if you visit the ccf.ca/donate. And as a registered charity, we do issue tax receipts. Okay, that's all for this update. Thanks for watching, and let's keep fighting for freedom in Canada.